Welcome to NYPTI's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nypti.com/law to read the full decision.
People v. Kenneth Townsend, decided May 28, 2026. Memorandum. The order of the Appellate Division should be affirmed, without costs. This Sex Offender Registration Act, SORA, Correction Law Art 6-C, proceeding arises from defendant's conviction of persistent sexual abuse. See Penal Law Section 130.53. In 2020, after twice being convicted of forcible touching and 8 months after completing a prison sentence for an unrelated felony, defendant approached an adult stranger in front of Penn Station, squeezed her buttocks over her clothing without her consent, and fled. Defendant was sentenced to prison for this crime. In anticipation of defendant's release, the Board of Examiners of Sex Offenders, BOARD, prepared a risk assessment instrument, RAI, assessing 65 points, yielding a presumptive risk level 1 classification. See Sex Offender Registration Act, Risk Assessment Guidelines and Commentary, at 3, 2006. As relevant here, the board recommended assessing the maximum 30 points under Risk Factor 9, which reflects the offender's number and nature of prior crimes, and the maximum 10 points under Risk Factor 10, which asks if the offender committed a prior felony or sex crime less than 3 years before the instant offense, excluding any time during which the offender was incarcerated or civilly committed. The board further recommended an upward departure to Risk Level 2, pointing to defendant's undisputed prior criminal history. The instant crime marked defendant's third sexual offense in less than 8 years. In 2013, defendant pleaded guilty to forcible touching in satisfaction of the additional charge of sexual abuse in the third degree. See Penal Law Section 130.55. In 2015, defendant pleaded guilty to forcible touching again, this time in satisfaction of the additional charges of endangering the welfare of a child, sexual abuse in the third degree, and harassment in the second degree. This conviction involved defendant engaging in sexual contact with a 15-year-old stranger victim and resulted in defendant's adjudication as a Level 2 sex offender under SORA. Defendant was also convicted of numerous other prior offenses, including attempted robbery in the first degree, a violent felony, attempted assault in the second degree, and several parole violations. In recommending an upward departure, the board reasoned that defendant's criminal sexual conduct was not deterred despite prior detection, sanction, and SORA registration, and that Level 2's more stringent registration requirements more accurately reflected the totality of his offense conduct. At the ensuing hearing, Supreme Court adopted the board's points assessment without objection and, at the people's request, granted an upward departure to Risk Level 2. The court readily and easily determined that the seriousness and extent of defendant's prior criminal history very plainly was indicative of sexual recidivism, that defendant's recidivism risk and danger to the community were extraordinarily high to a degree that the guidelines did not adequately capture, and that the totality of the circumstances warranted an upward departure. The Appellate Division unanimously affirmed. We granted defendant leave to appeal. SORA courts may depart from the RAI's presumptive risk level classification if special circumstances warrant. Guidelines at 4. See generally People v. Gelati. The departure mechanism recognizes that an objective instrument like the RAI, no matter how well designed, will not fully capture the nuances of every case. Accordingly, even where the law and the evidence warrant a particular risk level classification based on the defendant's guidelines factor score, a court has discretion to depart from that classification if there exists an aggravating or mitigating factor of a kind or to a degree that is otherwise not adequately taken into account by the guidelines. Gelati, quoting Guidelines at 4. A SORA court's determination, expressly made under the proper evidentiary standard and affirmed by the Appellate Division, is reviewed by this court for record support or an error of law. People v. Sherlock. See People v. Shader. People v. Lashway. Contrary to defendant's contention, an offender's prior criminal history can warrant an upward SORA departure in an appropriate case. Although such history is plainly a factor of a kind contemplated by the guidelines under risk factors 9 and 10, an offender's atypical prior criminal history may be an aggravating factor to a degree for which the guidelines inadequately account. Ghilotti. This case proves the point. The timing, nature, and extent of defendant's 3 sex offenses and violent felony supply record support for the affirmed finding that defendant's prior criminal history was indeed atypical. Risk factor 9 relevantly assesses the maximum 30 points for a prior violent felony, misdemeanor sex crime, or endangering the welfare of a child, or any sex offense. Guidelines, risk factor 9. Defendant's prior conviction of attempted first-degree robbery or either of his 2 prior convictions of forcible touching would thus have each independently yielded 30 points under this factor. Defendant stood convicted of all 3 crimes, yet he was assessed the same number of points under this factor as a defendant previously convicted of just one of them. Likewise, risk factor 10 assesses the maximum 10 points for committing the instant offense within 3 years at liberty after committing a felony or sex crime. Here, defendant committed the instant offense after 8 months at liberty following his commission of a prior felony, yet he was assessed the same number of points under this factor as a defendant who abstains from reoffending for more than 4 times as long. Given these facts, the lower courts did not err in concluding that risk factors 9 and 10 inadequately accounted for defendant's prior criminal history as an aggravating factor. Order affirmed, without costs, in a memorandum. Chief Judge Wilson and Judges Rivera, Garcia, Singas, Canataro, Troutman, and Holligan concur. Decided May 28, 2026.
Welcome to NYPTI's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nypti.com/law to read the full decision.